Hello everyone and welcome back to the channel. In this session, we will understand a topic from evidence law which seems to be very easy, which appears to be very simple, but it can be very confusing at the same time if you do not pay attention to the intricacies of the provisions. So in this session, we will discuss some basic points regarding primary and secondary evidence. We will see what are the provisions. We will then move on to the kinds of secondary evidences that are recognized by BSA. Are there any new additions to the same? We'll see. And then we will rest this session on that note, and there will be a second part in which some additional points, some very important points regarding admissibility will be discussed. So the idea to do it in two separate parts, two separate sessions, is to ensure that things do not get too overwhelming for us, right? So let's begin. Imagine with me that we are inside a courtroom and there is one piece of evidence that can tilt the decision in our favor. But we do not have it. We do not have the original with us. Or it is not possible to bring the original to the court. The question is there any other way by which we can prove the contents of the document? The answer is yes, and it is through secondary piece of evidence. Of course, not every thing other than the original document referring to the contents will be treated as secondary piece of evidence. What are the categories? We'll come to that later. But yes, through secondary piece of evidence, the contents of the document can be proved. Right? Now let's see some provisions from the BSA. See, this is BSA and see section 56. This used to be section 61 earlier under Indian Evidence Act. See, proof of contents of documents. The contents of documents may be proved either by primary or by secondary evidence. The law is allowing you to prove the same, the contents of the documents, either through primary or secondary evidence, right? Then primary evidence has been defined under the next provision. It means the document itself produced for the inspection of the court, right? But we have to read this provision along with section 59. Section 59 provides proof of documents by primary evidence. This used to be section 64 under Indian Evidence Act. It lays down what? Documents shall be proved by primary evidence except in the cases hereinafter mentioned. Right? So section 59 provides additional things. In a way, it is supplementing section 56. 56 is opening the window. It is opening the window to have either kinds, whether it is primary or secondary. But then 59 says what? That primary evidence will be given preference, right? When we read these two provisions, what comes out of these two provisions? Number one, the general rule is primary evidence will be given preference. Number two, secondary evidence can be allowed by way of an exception, right? And there is a very old decision from 1892, a very old decision which actually captures the essence of all this. You can note down, it was Lucas versus Williams. In this case, it was observed, I'm reading directly from it. In this case, it was observed, primary evidence is the evidence which the law requires to be given first. Secondary evidence is evidence which may be given in the absence of that better evidence, which means better evidence is what? Primary evidence, which may be given in the absence of that better evidence when a proper explanation of its absence has been given, right? So Primary evidence, general rule. Secondary, only by way of exception. And that too, when there is some explanation as to why primary evidence cannot be rendered as a piece of evidence. Then the reason for this preference is it is rooted in this philosophy that words they speak for themselves. And also the parties, when they have chosen to write down what actually transacted between them, then the same should be given primacy, right? Now the next question is, how do these documents will come before the court? Then we will move on to the secondary evidence. These documents will come to the court through different provisions. Under CPC, there is Order 7 Rule 14, which obligates the plaintiff to submit the documents along with the plaint. Then Order 8 Rule 1A puts the same obligation on the defendant. Then there is Order 16 Rule 6, under which the court can issue summons for the production of some documents. Then for criminal cases, we had section 91 CRPC, which has now become section 94. The court can issue summons for the production of documents under those provisions, right? Now we can shift our focus on secondary evidence. For that, let's see section 58 of BSA. I will also make comparison with the old provision. But let's start with section 58. 58 lays down the category of secondary evidence. The first clause, certified copies. Secondary evidence includes certified copies under the provisions hereafter contained, right? Sometimes people confuse these certified copies with the attested copies. This is not what is meant here. And when we read this in its entirety, it is under the provisions hereinafter contained. These words actually refer to section 75 of BSA. So it is only certified copies as per the requirements of section 75, which will qualify to be secondary evidence. Then second clause, copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies, right? Here, the second clause is giving us two additional categories of secondary evidence. First is copies that are made from the original through a process which ensures, through mechanical process which ensures accuracy of the copy, which includes this printing, Xerox, etc. Right? Suppose there was a report from a correspondent that has found place in the newspaper. So each copy of the newspaper, it is the secondary evidence, right? Then the second part of this clause is saying copies compared with such copies, right? It envisages that these copies, the copies that you're comparing, it means that they were not made by the mechanical process. So the copies compared, the word copies here, it includes copies that are made by human intervention, not by mechanical process. So any such copy which is compared with another copy which was made from the original through mechanical process, that copy also becomes that handwritten copy also becomes a secondary piece of evidence. This is what is meant here. Then let's see clause 3. Copies made from or compared with the original. Here it is only talking about the handwritten copies, the copies that are made by human intervention. So in such cases, you can the copies that are made directly from the original, they are also secondary piece of evidence, and copies that are compared with the original. So you are now not comparing it with the secondary evidence through mechanical process. Now you are directly comparing it with the original. That also, then in that case, the handwritten copy also becomes the secondary piece of evidence. Then there is clause 4, counterparts of documents as against the parties who did not execute them. Right? Let's understand this by way of an example. Suppose there was an agreement between A and B, and the agreement was, it was drafted in duplicate. One copy was signed by A and that copy was given to B. Then another copy was signed by B, and that copy was given to A. So the copy which A signed becomes the primary evidence as against himself, and as against B, it becomes the secondary piece of evidence. This is what is meant by counterpart. So counterpart of documents as against the party who did not execute them, right? Understood. So that copy which is with B now, signed by A, that duplicate, that was a counterpart document. So B, if B submits the same in the as a piece of evidence, then it is a secondary evidence as per clause 4, right? Clause 5, oral accounts of contents of a document which of a document given by some person who has himself seen it, right? Somebody who gives the oral account of the contents of document, the document which is seen by him also qualifies to be a secondary evidence. Now here the word seen is used. The word read is not used. This is majorly because of the reason that the word document under the BSA and under the Indian Evidence Act also, it has been defined in such a way that anything recorded on any matter by way of letters, figures, marks, they qualify to be a document. So there can be some documents, for example, a painting. A painting is also a piece of document as per the definition of document in the Act. So for such kinds of documents, you can also only see them and describe what you have observed, right? That is why the word seen has used, not the word read has been used. Now let's pause section 58 for a moment. We'll see the rest of the categories in a while. And now let me take you to section 63 from Indian Evidence Act, which defines secondary evidence. When we see this provision, see here only 5 categories are provided, which means BSA has added in the corresponding provision 3 additional categories. But let's understand, are they completely new, or they were in a way recognized by the Indian Evidence Act itself, right? For that, we need to refer to 2 provisions from Indian Evidence Act. One is section 22, another one is 65, but let's see section 22 first. When oral admissions as to contents of documents are relevant, right? So contents of documents, we have seen the provision. How can they be proved? By primary or secondary evidence, right? Now here oral admissions are also relevant under section 22. See, oral admissions as to contents of document are not relevant generally until and unless the party proposing to prove them shows that he is entitled to give secondary evidence, which means if any explanation is given which will enable the party to give us secondary evidence of the contents of the document, then oral admission also becomes a relevant fact, which means oral admission will be treated as a secondary piece of evidence, right? This is the effect of 22. Oral admissions are secondary evidences provided there is an explanation coming as to why you are proving it, right? You are entitled to give the secondary evidence. Generally, they are not relevant. This is what section 22 says. But for our purposes, we find that one additional category is oral admission. Oral admissions can also be secondary evidence, right? Now let's see 65. 65B. When the existence, condition, or contents of the original have been proved to be admitted in writing. Admitted in writing, right? So such written admissions can also be taken as evidence in the form of secondary evidence of the contents of the original. So we find another category. Let's see G. It is provided when the original consists of numerous accounts or other documents which cannot be conveniently examined in court, and the fact to be proved is the general result of the whole collection. Then read from here. In such case, evidence may be given as to the general result of the documents by any person who has examined them and who is skilled in the examination of such documents, right? So such general result also qualifies to be a secondary piece of evidence, and it is exactly these three categories which have now found the place under BSA. Now see rest of the three categories, the last three categories. This is 58 BSA. Oral admissions, right? Already recognized. It is not something new here, right? It was already recognized under Evidence Act. Written admissions, 65B. Evidence of a person who has examined a document, the original of which consists numerous accounts. So and so we have already seen 65G, right? So now they have explicitly provided under the definition of secondary evidence, though they were already recognized under Indian Evidence Act in one way or the other, right? The next question that we should ask is whether there is a an order of merit within these categories, in the sense that the first category will be preferred over the others if you have, let's say, certified copy, or let's say not certified copy. Certified copy will create more confusion. Let's take another example. If there is a some document which qualifies under category B, and you also have some oral accounts which can be given, you have seen the document, then in that case, will the court say that no, you can only give the first category of the secondary evidence because there is an they are mentioned in a specific order under the provision. That is not the case. That is not the case, and it was clarified by the Supreme Court in one decision. You may note down. The decision was M. Chandra versus M. Tanagu Muta. Sorry, Mutu. Tanagu Mutu, 2010, Volume 9 SCC 712. Right? But when we read section, let me just show you again, share my screen. This was also under 65. Now, yes. See, when we read section 60 now of BSA, you will find that certain kinds of uh, evidences, secondary evidences are only allowed in certain cases. For example, in cases of public documents, you will find that only the certified copy is allowed. See F. Only the certified copy is permitted. And in case of public document also, right, 74. See here it is provided in case of clause E or E or F, a certified copy of the document, but no other kind of secondary evidence is admissible. That is the issue. And we can also see, we have already seen this B and G. In case of written admission, only written admission will be admissible, right? In case of general result, only that is admissible. So though there is no order of merit as decided by the Supreme Court, but there are only certain kinds of secondary evidences which are allowed in certain cases to prove the contents of the original, right? We will end this session here, but there will be a second part also. As I have said, otherwise things will become very overwhelming for us and we will not understand the essence of these provisions. So far we have only discussed what is primary, what is secondary, why preference is given to secondary, and we have analyzed some of the categories along with the meaning of the words that they carry, right? On that, I will just take your leave for the day and we'll meet again with the second part. Right? In case you have any doubt from these provisions, let me know. Yes, good afternoon. Good afternoon, Kanaya. Let me know if you have any doubt. Any doubt so far? And sometimes these categories can be confusing, and ultimately when you practice in the court or you serve as a judicial officer, they will haunt you if you will not understand them properly. Recently, I came to know that one of the judges insisted upon the certification of electronic uh, evidence, though it was primary in nature. And the court has time and again clarified this position that if electronic evidence is primary in nature, then what is the need of certification? It was because the confusion was because of the fact that there was not a complete understanding as to what is primary or what is secondary. And that is why it is important to understand. Let me know. Any doubt? Any doubt? Any doubt or any comment? We welcome everything. Thank you. Thank you. Thank you. Okay, then we'll meet again with the second part. Thank you. Thank you so much. If any document not read by someone, how to testify if the document is same as you have seen? Then in that case, it will not be permissible, not admissible at all. Oral account of the contents of the document can be given as secondary evidence only when you have seen it yourself, right? If I have seen it and then I tell the contents to you, and then you are the one who wants to testify about the same, not admissible as secondary evidence. The provision is clear. It is only by the person who has seen. Any other doubt? We'll examine the admissibility in more details in the second part. Okay. Yes, yes. Seen and not read, it is used because seen, it came for consideration before the court also, but not in India, in some other jurisdiction. So the court was of the opinion that the word seen is more appropriate than the word read. Why? Because seen in the context of the documents that can be read. The word seen caters to every kind of document, including such kind of document which can be read, right? So seen was more appropriate. As you have seen that some kinds of documents, they cannot be read, they can only be seen and observed. For example, painting, for example, photograph, right? They qualify to be a document. That is the reason, right? So seen includes the word read within it when we read this provision. Understand it in this way. What else? Okay, thanks a lot. Now clarity came. Thank you. Thank you. In the second part, I'll also come with that decision. I'll find out where it was said that scene includes the word read within it as far as secondary evidence is concerned. Right, or some other authority. I'll give it to you in the second part. Don't worry. It is with me, but it is not. It is downstairs in a different book. Okay. Okay, then we'll see. We'll meet again with the second part. And do subscribe to this channel if you have not subscribed so far, so that you do not miss out on such sessions. Thank you. Thank you for connecting today. It is always a pleasure to discuss things with you and address your doubts. Take care.